Honorable Chief Justice and Justices of the Supreme Court of Ohio. Hear ye, hear ye, hear ye. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning. Please be seated. In our first case this morning, 2024-0303, in re L.E.S, E.S, N.S. On behalf of the appellant, Mr. Kerridge. Good morning.
Good morning. Chief Justice, and may it please the Court, my name is Paul Kerridge, and together with co-counsel Alex Durst and Diana Link, I represent the appellant Priya Shahani. I would like to reserve 4 minutes for rebuttal, please. There are several moving parts to this case, but I think we can boil it down to issues of consent, and that covers everything. Now, I've tried to break that down into 3 subcategories. The first is consent to marry. The Supreme Court decision in Obergefell means that states must provide equal rights to marry to same-sex couples and different-sex couples, but there is no requirement that states provide those same rights to unmarried couples, and there is no requirement that states recognise common law marriage. The second part is parental rights. A host of precedents, including the Supreme Court's decision in Troxell versus Granville and the Ohio ART statute, show that a state cannot diminish a parent's rights based on reimagining a fictional past. And third, a would-have-been married standard is unworkably speculative because every factor in that standard would also apply to long-term relationships that didn't include a marriage. So let's start with Obergefell and see where we go from there. Obergefell had 2 holdings. States must issue marriage licenses to same-sex couples in the same way that a state would issue marriage licenses to a different sex couple. Second, states must recognise out-of-state marriages for same-sex couples in the same way that states recognise out-of-state marriages for different sex couples. The knock-on effect of that is that states must provide to same-sex couples the constellation of benefits of marriage.
Is the shared custody agreement in dispute in this case?
So there's 2 parts to my answer. The first part is yes, it is in dispute, but that part of the case was never resolved by the First District.
It's not in front of us.
It's not in front of you. No, we're talking.
So if the shared custody agreement continues, which it has so far, as a matter of fact, I know as a matter of law there might be difference, but as a matter of fact, day to day, for the best interest of the children, anything we decide here doesn't change a thing.
Anything you decide here today in terms of...
Because the shared custody agreement continues.
Well, there's a shared custody agreement for one of the 3 children.
The trial court found it applied to both, all 3.
Right, and that is on appeal to the First District, and the First District never ruled on that.
But in front of us, it doesn't exist.
Right.
So anything we say really has no effect on that.
Anything you say has no effect on the custody agreement. That's correct.
So de facto, whatever we say is irrelevant.
Well, there's a very big difference between custodial rights and parental rights. There's some cases, Bonfield and Mullen, I think, are the 2 cases out of this court that say that a party can contract custodial rights, but a party can't contract parental rights. And those are very different sets of rights. So what we're here to decide today is whether the parental rights are provided to a person who is not a biological parent and not a parent under any of Ohio's statutory schemes. And then we go back to the First District, assuming you agree with me, and then we find out the custody issues. So it's a little bit of, I would say that puts the cart before the horse somewhat, because we first have to determine whether the greater parental rights are given to the appellee here before the custody rights issues can be fought out. So, but when we talk about, I'm going to circle back to marriage here for a second. When we talk about marriage, there's really sort of three states that a marriage can exist in. One is people just aren't married. Two is people have a solemnized union. And third, people have a union based on sort of course of conduct. And the term we use for that is common law marriage. Ohio doesn't recognize common law marriage. That statute needs to be read in sex-neutral terms under Obergefell, but read in sex-neutral terms, it applies equally to different-sex couples and same-sex couples. So there's no problem with the common law marriage statute in Ohio. It's equally a blanket ban. So what we're left with here is really what the First District did, was create common law marriage without saying that there was a creation of common law marriage, and created an exception to a statute without ever saying that's what they were doing. There is no solemnized marriage in this case. There cannot be a common law marriage in this case. So we're left...
The commitment ceremony, characterize that for me, if you would.
So there's a dispute about whether that happened, which is why sorry, it's kind of difficult to answer your question because I just say there wasn't one. I mean, so that doesn't really, that's something that needs to be flushed out below, but that's not a marriage. That's, I mean, like...
Well, even if it were not in dispute that there was a commitment ceremony, how does that differ from a marriage? And is that something that the First District relied on, or is it just there in the facts? It's there as a contested fact, but that wouldn't make any difference because doesn't follow the Ohio statutory scheme for a marriage. Thank you.
So it really is just, look, and I'm going to sort of skip ahead a little bit here and really talk about injury or at least redressable injury is if in some hypothetical situation somebody had traveled out of state and got married, lawfully in Massachusetts or California or something, some state that recognized same-sex marriage long ago, that would be a different scenario where there is a marriage that is recognized. But here we don't have a marriage that's recognized in any state, and there's a big difference between a sort of, even if a commitment ceremony did happen or some other kind of quasi-ceremony, it's not a marriage because marriages have licenses and they have signatures and they have a sort of, it's a known entity of what kind of relationship and the change in your personal rights and obligations. That's a known entity that you're entering into, whereas a commitment ceremony is not like that. In fact, one of the, and you'll forgive me for not remembering the name of the case, but one of the cases talked about mutual assent, which I've sort of redefined as consent. There can never be a marriage without mutual assent. And here, that's what we're kind of getting is one person saying, well, I want a marriage to be retroactively created, and another person saying, well, I don't want a marriage to be retroactively created because I never wanted to enter into one in the first place. And because there was no marriage and there was no challenge to the ban on same-sex marriage at the time, no contemporaneous challenge to that. There was no attempt to get a marriage license. We actually don't have a redressable injury here, which I guess I could kind of look at as a standing issue, but I think it's probably cleaner to look at it as no injury. This would be similar to one of the cases that comes up quite a lot in the briefing is a case called Troxel, and that's about grandparent rights. If I wanted to stand up here and challenge the grandparent right statute, one of the things that would have to happen is there would have to be a grandparent trying to exercise visitation rights. And here what we had was a person who apparently disagrees with the ban on same-sex marriage but never tested it, never challenged it. So we would have needed, at minimum, an application for a marriage license in Ohio, or it would probably be a cleaner set of facts if there was a challenge to recognition for out-of-state marriage, out-of-state same-sex marriage. Then we would have an actual injury because you could say, well, you wanted to do this thing and you were stopped from doing it. So now we challenge that statute. But that's not what happened here. We basically had you could call it acquiescence or obeying a statute, whichever way you want to phrase it. And there was just no attempt to challenge the statute. So there's no injury caused by that statute. So,
You think the First District seemed too eager to redress an injury that perhaps did not exist?
Yeah, so that's right. The First District is attempting to create a standard that corrects an issue that is never going to be an issue, because to apply all of the marriage-based statutes, there has to be a marriage, or a marriage that wasn't recognized and then you challenge the lack of recognition. And that's just not what happened here. We have two people who didn't get married, and now the First District's decision is basically a way to shoehorn into a relationship, a marriage, so that we can apply marriage-based statutes like the ART statute, which only apply to married couples. We can read that in sex-neutral terms and just replace husband and wife with the word spouse, and then it's a constitutional statute. It doesn't do anything to, once you read it in sex-neutral terms, there's nothing unconstitutional about that statute. And if, in reading the First District's opinion, the First District never found any statute unconstitutional other than the same-sex marriage ban that's controlled by Obergefell anyway, but instead tried to rewrite the ART statute, the common law marriage statute, and sort of take, I'm having a hard time articulating because it was a strange thing to do, take one statute that was unconstitutional and then rewrite a series of other statutes that are constitutional as a way to create a remedy for an injury that never happened. So it's a little difficult to articulate exactly what the First District decided, because really there wasn't a lot said in the First District other than it feels like we want to give some rights here, not really sure how to do it, so let's just create a fictional standard. I see I've saved a few minutes here for rebuttal, so I think I'm going to pipe down unless there are any more questions, and I'll come back and finish up then if that's okay.
Thank you.
Thank you so much.
Mr. Hilton, good morning.
Good morning, Your Honors. Jonathan Hilton for appellate Carmen Edmonds. Chief Justice Kennedy, and may it please the Court, with me today is co-counsel Danielle Levy, and seated in the front row is my client, Ms. Carmen Edmonds. With her are just a few of the non-biological parents who had their children prior to Obergefell, and for that reason have either lost a parent-child relationship or who are facing the very real threat of that loss. And I want to focus in immediately on Justice Fischer's question as day-to-day, why does parentage matter? Why is custody not enough? I'll say that custody is a poor man's version of parentage. In this particular case, if you're thinking about the day-to-day life of Ms. Edmonds, she struggles to get medical records for the children. She struggles to get school records for the children. And she's really at the other parent's whim. Custody, as well, lacks the legal stability that Justice Anthony Kennedy in Obergefell said that the children who are at issue in these cases deserve. And I'll give you an example of that legal stability. In this case, my client didn't have standing and didn't even receive notice when Ms. Shahani changed the children's last names in probate court. My client wasn't able to contest that at all. So you have children who have hyphenated last names, their very identity is being changed, and my client has no more rights in that situation than a babysitter. In terms of custody as well, there's sort of a playbook that's developed in the same-sex community, and we can see down the road to what can happen. Ms. Shahani has now remarried. She has married the nanny that she ran off with when she left the children with my client. And the next step in that chain, if she petitions the probate court for an adoption, my client will have fewer rights in that hearing than a deadbeat dad.
So tell me about what the shared custody agreement does allow for. regarding the firstborn, but also as applied by the trial court to the twins.
The shared
What does that
custody-
allow your client to do?
The shared custody agreement allows my client time with the children, so she has roughly now about 30% of the time. And she would have a right to attend the probate hearing if there were an adoption in the future. But she's not entitled to the same rights that a dad would be, even if we're talking about someone who had been fairly absent from the children's lives. And my client has been there since the very beginning. She planned to raise and conceive these children with Ms. Shahani. Magistrate David Kelly in the trial court found that my client was had acted as a loving parent and had a bond with the children equivalent to a mother-child relationship in every single way.
So they went to Boston and they didn't get married before they had the first child. Was same-sex marriage permitted in Massachusetts at the time?
Yes, Your Honor. Same-sex marriage was legalized in Massachusetts in 2004. And if you're thinking about the timeline of this relationship, Ms. Shahani and Ms. Edmonds were together in 2003. So they exchange rings and they go to Boston when it becomes legal. But while they are there, and this is a testimony in the record, while they are there, they realize that Ohio would not recognize their marriage when they returned. And according to the testimony in the record, that is the reason that they didn't get married in Boston.
So they went all the way to Boston to get married, and they didn't realize, they didn't try to find out before they went whether Ohio would recognize the marriage? That seems a little incredulous.
Well, Your Honor, first I'd say that's an issue of fact for the trial court to determine on remand. But in
Well, let's talk about that. That's, I mean, aren't you, it seems like you're advocating for really an impossible standard. You're going to have one parent who says, I wouldn't have get married. The other one says, I would have got married. I mean, how can a court really sort that out? I mean, because no one actually knows what someone would have done, and if they would have been married, the rights would have been different. I mean, it seems like a purely hypothetical exercise that I'm not sure how any court could really sort out.
Your Honor, I have a few very important points to make to that. The first is that this is an as-applied constitutional challenge. So if you look to this court's case law, our standard of proof, our burden of proof, is clear and convincing. So that's going to cut out a lot of the he said, she said, because the juvenile court is going to need to find by clear and convincing evidence that Ms. Shahani would have married my client. I want to point to some pieces of evidence that the juvenile court would be likely to consider.
But I also want to follow up again on the Boston situation, because from what I'm familiar with of Jim Obergefell's situation, he married his husband on a tarmac in, I think it was Boston, but it was in a state where he was permitted to be married, knowing that his partner was not going to live very long. And so there was that issue of consent there, that both parties wanted it regardless. And we don't, what proof do we have of that consent to marry when they didn't get married?
My client proposed with a diamond ring, and Ms. Shahani said yes. They gave their children then hyphenated last names. But I want to point out to a strong
But
piece of...
proposing is different than actually getting married, right? I know lots of people who've proposed, been engaged, have never been married. And the question is, how do you know, how could someone ever figure out whether they actually would have?
If you look to the order, okay, if you look to the order, the very first one in the case in 2012, where the two parties are putting on that shared custody agreement for the oldest child, you'll find that on page 4, in paragraph 9, they say that what their intention is to bring future custody disputes under the umbrella of RC 3109.04. That's the shared parentage statute. So we have consent. This is a document that was drafted by Ms. Shahani's lawyers while my client was pro se. We have her consent here to shared parentage. And the only way that they could have gotten shared parentage would be to have this kind of a union. So we know that she consented, or at the very least, we'll be able to prove it by clear and convincing evidence when we get back to juvenile court. And I want to focus on the...
But it was still a shared custody agreement, though, correct?
It is a shared custody agreement, but if you look to what they actually wrote, they're saying shared parentage in the document in that paragraph, and you can tell that's their intent. I want to talk about the supposed unworkability of this standard, because courts use a would have done this particular thing standard all the time. I want to point out a very interesting case. It's a concurrence by Justices Fischer and DeWine, and it's the case in re adoption of AK. That's 2022 Ohio 350. And in that case, the question is, should a father lose his parental rights because he hasn't contacted the child due to a court's no contact order for over a year? And what Justices Fischer and DeWine said in their concurrence is that what you want to look to is whether this father would have contacted his children but for a no contact order. And the evidence that that concurrence points to is that the father had written his child some 200 letters that he would have, according to his testimony, delivered to the child if he had been able to. So it's the same type of inquiry, same kind of analysis. Would Ms. Shahani have married my client? It's important to note that Magistrate David Kelly below found that Ms. Shahani was not a credible witness. Magistrate Kelly found that Ms. Shahani's actions around the time of the children's births and in the early relationship spoke louder than her words. So when you think about the evidence, and by the way, Ms. Shahani never testified at trial that she would not have married my client. The evidence in the record is from my client about their discussions, their plans to get married, their future together, their dreams. So let us go back to the juvenile court and meet that clear and convincing standard, because we have the evidence, we have the record already, and we'll be able to show it.
Well, let me ask something. Are you asking us to affirm First District opinion?
Yes, Your Honor. Affirm the First District's opinion, and if you wish, you can put in the slight modification that the burden of proof is clear and convincing, because I will readily concede that. Well,
let me ask you then, paragraph 34 of their opinion, first sentence. If it is credibly established that the parties would have been married at the time a child was conceived absent the ban, then this court is of the opinion that marriage should be recognized for the purposes of determining parental rights, particularly under Revised Code 31111.958. That's the whole sentence. You got an if, you got establishment, you have a would have been, you got absent the ban, which is the but for you're talking about. The marriage should be recognized. Aren't they asking us to give an advisory opinion on a hypothetical question?
I think what Your Honor is asking is whether there's a possibility that you should IA the case. Because
I didn't ask that question. I'm asking, are you asking us
no, Your Honor,
to uphold that sentence?
I'm asking you to uphold the sentence. However, I do think that the way that I have phrased it in my brief is somewhat easier to follow, which is what I do in my analysis is that I look at the artificial insemination statute, and I look at the classes of people that it protects and the people that it doesn't protect. The people in this case that it doesn't protect are non-biological parents who had their children prior to Obergefell. And I asked the court, following the same procedure that it did in re adoption of YEF, to extend the statute rather than strike it down. Because if you rule against my client, and we know that there was a constitutional violation, that brings the entire statutory scheme into jeopardy. The statute would have to be struck
But they never
down.
challenged the statute, right? I mean, they could have filed an action to challenge a statute when they entered into this, but they didn't do that.
Your Honor, my client wants to be a mom. She's not an activist, and she's not a protester. There's no requirement in terms of the timeliness of her challenge that she have done so at that exact time. Parents all the time bring up custody and parentage issues when there are disputes in a juvenile court.
But
We asserted Ms. Edmonds' parentage as a defense when Ms. Shahani moved in the juvenile court to terminate my client's custodial rights.
But even if the trial court, to that sentence, finds the if, aren't we just upholding then a common law marriage?
No, Your Honor, common law marriage is for slackers.
Right.
Common law marriage is for people who could have gotten married under Ohio law, but they chose not to. My client's no slacker. Look at all the paperwork she signed and how hard she thought about this decision, trying to find a way, but she couldn't. She had no path for Ohio to recognize the marriage. We have someone who wanted to marry, a couple who wanted to marry, but Ohio gave them no path to recognition to that legal status. So those are opposite things. And I'd add that we are just focused on parental rights here. We're not asking for any property rights. We're not asking for every kind of finding that a common law marriage might bring. We're just focused on the rights that matter to Ms. Edmonds here and to her 3 children, and that's parentage.
Does the best interest of the children matter? In this case? I
Your
mean,
Honor,
in general, it does, but
Yeah.
in this case.
In this case, it's in the best interest of the children to have the legal recognition and stability that Obergefell promises them.
That didn't answer my question. Is the best interest of the children relevant to this legal issue here today?
Your Honor, the court, in making the would have married determination, can look at the family life and the structure, and that could inform how it answers the question. But legally and constitutionally, the relevant question is, would the parties have been married at the time of insemination? And I would refer this court to the Ayala case out of the District of Idaho, which is, by the way, a common law marriage state. I see that my time has expired. If there are no further questions.
Thank you. Mr. Kerridge, you have 3 minutes, 42 seconds remaining.
Mr. Kerry, can you address the best interests of the children and what or how that applies in this case?
Sure. So best interest of the children is a custody consideration, not a parent consideration. Under Troxel versus Granville, that's the United States Supreme Court case that said barring neglect, the parental autonomy is not something that a state should interfere in or the courts should get involved in. So best interests of the children are not part of the parent analysis. Like, best interest of the children is definitely part of the analysis of the custody agreement, and that is currently not before this court. And what we would ask the court to do is reverse and remand for the First District to address several unaddressed assignments of error, and the custody analysis, which includes the best interest analysis, is part of that equation, not part of the issue before this court. Would have been married and best interest of we don't find, no common law marriage in Ohio, but there's an exception to that. If it's in the best interests of the children, then we do find common law marriage. That's not the law in Ohio. The law in Ohio is common law marriage doesn't exist. That's it. It doesn't matter whether there are children that would be interested or serve the best interest if we create a common law marriage. Let me just touch upon a couple of things that my friend on the other side said here. So one is this is an as-applied challenge, apparently. I still don't know what statute the First District said was unconstitutional, because there's no There's no information on that in the decision. That this was not an as-applied challenge to a statute. It was a challenge to one statute that everybody knows is unconstitutional under Obergefell, and then just create everything else out of whole cloth to try and get a remedy that just doesn't make sense because there's no injury. I want to talk briefly about the trip to Boston. That was in 2014, and Ms. Shahani was already pregnant when the couple traveled to Boston. Ms. Shahani would tell you that there was no part of that was about them getting married. It was going to a friend's wedding, not about Ms. Shahani and Ms. Edmonds getting married. The workability, oh, I'm sorry, let me correct one fact as well. Ms. Shahani is not married to anyone right now. Ms. Shahani is not married to anyone because she doesn't believe in the institution of marriage, which is how we know she wasn't going to get married to anyone. It's not for her. She's not married to her current partner. They've been together for a decade or so. So just with that fact corrected, I want to talk a little bit about the difference or the similarities between property rights and every other set of rights that's mentioned in Obergefell. If the court was to say that would have been marriage standard and we're going to recognize marriage for purposes of parentage but nothing else, that would violate Obergefell. Obergefell says the constellation of benefits of marriage must be provided to same-sex couples. Not one above the other, not some rights are more important than other rights. And that sort of ties in a little bit with the question about improvidently accepting the case. This standard will cause all manner of challenges to various decisions and various issues to do with property rights, intestate succession. They're all in the brief. There's a parade of horribles section at the end that I think will be good to review. And I see my time is up, so unless there are questions, I will pipe down.
Thank you. We'll take the matter under advisement. You will receive a decision from the court. Thank you.